Thank you, Phil, and thanks for the people who are joining. So my name's Larry Crowther. I'm at Wegman Hessler. We're about a 25 lawyer firm right on Rockside Road, just down the street from Parma. So you can visit our offices without having to go downtown and deal with all that. I did want to say as an administrative matter, we are going to record this presentation, and we'll be putting it on our website later. And I think Phil is going to put it on the Parma Area Chamber of Commerce website. So looks like we have a small group, which I actually look forward to, that hopefully we can get a lot of interaction from people. My general plan here, so the topic is organizing a small business entity in consideration of buy-sell agreements. I plan to quickly go through the different types of business entities, and we can have some questions at that point. And then I'd like to spend more time talking about buy-sell agreements, which I think are very important. And a lot of small businesses decide that they don't want to spend the money on having a buy-sell agreement, and they can become a great time and money-saving agreement, if something happens to one of the owners. So,
hey, Larry,
yes.
Larry, before we begin, since we have such a nice intimate crowd, is there a benefit for everyone just to say who they are in their business?
Sure.
That's great.
So I guess go ahead,
So
Judy.
all right. So Nikki, why don't you go? We've heard from Phil. Why don't you go, Nikki?
Hi, everyone. Thank you for coming for this Zoom at noon. My name is Nikki Sulandari. I'm with Edward Jones, and I'm the board of Parma Chamber of Commerce. Thank you.
Excellent. How about Mark Delaney? If you could unmute.
Hi there. My name is Mark Delaney. I am a board member, plus I also work for M&T Bank, doing underwriting.
Excellent. Thank you for joining.
Thank you.
All right, and our next guest is Rob Brill.
Good afternoon, Rob Brill. I am with Cox Communications.
Excellent, thank you. How about Ken?
Hi, I have a company called True Test Screening. We're a employee screening company, and I'm also on the board of the chamber.
Nice, welcome. Thanks so much. Okay, Katie.
Hey everyone, I'm Katie Donovan-Anders. I work at the Cleveland Metropolitan Bar Association and manage our lawyer referral service, where people can come to get a referral to an attorney for business needs or for personal needs. And happy to say that Larry is one of our attorneys who's part of the referral service.
Some very interesting referrals over the years.
We have. You've been super helpful. So I appreciate that.
Katie, thanks for your support. How about Terry?
Good afternoon, Terry Colleen. I'm with First Energy, and I focus my municipal leadership relationship efforts throughout our CEI and Toledo Edison areas. Glad to be here.
Excellent. Thanks for joining us. All right. So then I think our next one is Kevin Smalley.
Good morning. Sorry, I got to figure out where my camera is.
You're good.
I work with the Illuminated Company as well. I'm a regional external affairs consultant for Parma area, part of the Parma Chamber.
Excellent. All right. So wait a minute, couple. How Kareem, Maine?
Can you hear me okay?
We can now.
All right, perfect. Hey, I'm Kareem Main, recently new board member here from General Motors and Parma Stamping.
Excellent, welcome. And did we get everyone?
You didn't introduce yourself, Judy.
Okay, hi, I'm Judy Bodenhammer, and my organization is the Client Experience Group, and I have the pleasure of working with Larry and the team at Wegman Hessler, as well as a variety of other businesses in the region. And I am born and bred. I grew up in Parma. I grew up in Parma Heights, so I'm all with you in the Parma Chamber. All right.
Parma area.
So there we go, Larry. It's all yours.
Okay, very good. Okay, again, thanks for joining everybody, and let me give a little background about the firm. So we represent a lot of businesses, from small businesses to large international businesses. I enjoy working with the startups and the smaller companies, which then we have the opportunity to grow with them. And most of our clients we've had for decades. So our intention is to work with businesses and their owners and work through the generational issues. So we really enjoy working with businesses. We also have full service. We do the estate planning. We have 5 intellectual property lawyers for patents and trademarks. We have business litigation, and we also handle domestic relations as that might be needed. So here's the topic again: organizing a small business entity in consideration of buy-sell agreements. What I'm hoping to do is not just read what's on the PowerPoints. Those are available if anybody wants them later. I'd like to just kind of jump through these fairly quickly, and again, then get to the discussion about buy-sell agreements, and then any other general questions you might have. So there's, if you're just open up you're put a sign on your door and open up and don't have an entity, that's called a sole proprietorship. Typically John Doe, DBA, whatever your business name is. One of the main concerns with this obviously is whatever liabilities that the company has, you have personally, so your personal assets are at risk. There's partnerships, which I don't think really apply here. They used to be used more often. The old workhorse is a corporation, been around forever. And you can, depending on how you want to be taxed, you can either have that as a pass-through entity or a C Corp. And then the more common type of entity that's used now is the limited liability company, or LLC. So just the reasons for the choice of the entity, one of the again, main issues is to limit any personal liability if you're conducting business. It also allows you to have an entity that you can then transfer ownership to your children or to sell the entity. And there's obviously tax issues involved, so you need to coordinate with your accountant. One of the issues that we run into a lot is people will either, it used to be the accountant would do it, not speaking badly of accountants, they would just file the articles and not do the rest of the organization of a corporation. And what we find now more commonly is people just go on the internet or just go on the Secretary of State website and do it themselves to file the articles of organization or incorporation, but they don't complete the organization. And if you don't do that, then you run the risk that a creditor would come after you personally. So I think we talked a little, we already went over the sole proprietorship. So we can go on to the next one. Again, partnerships are not really relevant for general business. And then the entity most people have historically used, again, as a corporation. So real generally, the tax issue is that normally a corporation is taxed as its own entity. And if the company wants to distribute money to the shareholders, it pays a dividend. And then there's 2 layers of tax that happen at the corporate level, and then again at the shareholder level. One way to reduce that is with a corporation, a subchapter S, where the corporation itself is not taxed. All the financial activities of the company pass through right to the shareholders. Now, a problem with this is if you want to keep the money in the corporation to grow it, if you're a sub S, you actually have to distribute out. The owners are going to owe tax on the income, whether they have cash or not. So typically the businesses are in a situation where they have to distribute out enough cash to at least cover the taxes. So that's one of the issues you need to talk to your accountant about. So corporations require formalities. You have to have code of regulations. You have to have an initial and annual meetings of the shareholders, meetings of directors. And if you don't do that, again, this is one of the factors that can be held against an entity where a creditor might try to pursue the owners personally. In Ohio, there is a quote, close corporation that allows relaxation of some of these formalities. That was starting to be used, and then the LLC law came into effect. So let's see. I think we covered most of that already. If we jump to the LLC. So in Ohio, this law was enacted in 1999, and it's really very quickly become the entity of choice for most businesses. It allows for much more flexibility. You don't have to maintain they have members, which are the equivalent of shareholders, and then managers, which are the equivalent of the board of directors. For an Ohio LLC, you do not need to have a board of managers. You can just be member managed. You don't have to have annual meetings. And just a lot of the formalities are not required, and then that's not held against the entity if a creditor is trying to pursue the individual. Just a practical matter, when you set up an LLC and you need to open a bank account, first question the bank asks, they want your articles, they want an operating agreement, and they want your employer ID number. So if you know, you think you just file your articles and you have an LLC, you're going to quickly find out that that's not comprehensive enough. So again, with an LLC, with as far as tax, there you can have what's called just a straight pass-through, like a partnership. Then you get into partnership tax rules, which are very complicated. You can elect to be a C Corp and you can elect to be an S Corp. And there's employment tax reasons why you might want to do it as an S Corp as opposed to a partnership pass-through. Basically, you got to withhold employment taxes if it's being paid out to people as an employee, where you can, as long as you're paying reasonable compensation, you can pay out additional amounts as a dividend that are not subject to the employment taxes. But there, again, there's a lot of qualifications to that, so you need to talk to an accountant. Again, you need to get an employer ID number. So I think next slide, these are just other business entities that are specific, like lawyers have legal professional associations. There's a whole another area of nonprofit corporations that we do some work in that area. That's a whole separate set of entity organization documents and issues, particularly with regard to tax filings. So before we jump into the buy-sell, are there any questions? Again, we have a small group here, so please feel comfortable to either ask on online here or in the chat.
Phil. Oh, Phil. Larry, I
Yes.
have a question for you. What
Yes.
is inside the article? What is that all included in the article?
Okay, so the articles are filed with the Secretary of State of Ohio, if you're assuming you're filing in Ohio. Typically, there's 4 or 5, depending if you're doing a corporation or an LLC. Basic sets of information. You need the name, you need your purpose, which you can just say it's any legal purpose. You need a statutory agent if there's no formal notices, tax, or if there's a lawsuit filed, you need a statutory agent to receive the mail. And so that's a very short document. It's very easy to file that. That's public record. If you have a corporation, Ohio, we call them a code of regulations. Most states call them bylaws, but it's the same thing. And for an LLC, it's called an operating agreement. Those are internal documents. Those are not available to the public. So typically you file only the minimum that you need to file in your articles, and then you have all your internal governance matters in either your code of regulations or your operating agreement. In the articles, if you have a complex ownership structure where you have Class A and Class B voting and non-voting shares, or if you have preferred shares, those need to go in the articles. For most small businesses, you don't need a complicated set of share or unit classes. I think I just saw a question. What is a statutory agent?
And
So
before,
that's,
yeah.
so it's a person that you have to reside in the state of Ohio. You have to have a physical address. It's not just a PO box. Typically, it's either the business owner or you have one of the lawyers do that, since it's, I can say politely, kind of you get a lot of nuisance filings where you get a lot of junk and you get tax notices. But it's good to have, if it comes here, then we process it. We make sure you have it and there's a record that it's been received if it's something that needs to be attended to. So it's whatever the client preference is for that, whether they want to be the statutory agent or again want one of the lawyers here to be the agent. Sometimes accountants will do it too.
That's
But,
great. We have a person that raised their hand, Mark Delaney.
Yeah. Two things. And working in banking, I see it from that side on the loans and on the opening of businesses. Can you tell us about the importance of when you're filing for the name of the business through the state? And then also, a lot of times we have people out there who are using LegalZoom, or maybe they are opening a branch of a business, like a franchisee, how that comes into play with respect to the registration of the name.
All right, so the name, you have to first make sure the name's available. And the Ohio Secretary of State, I mean, it used to be the lawyers would have to do that with a kind of a formal search procedure. Frankly, anymore, you can go on the Ohio Secretary of State website. It's very easy. You go under businesses and you type in the name you're looking for and see if anyone already has that name. So obviously you don't want a name that's confusingly similar to another business that's existing. It used to be, if it was even remotely close, the Secretary of State would reject it. Now it has to almost be exact. So people get pretty close to existing names and might get pushback. But so that would be the first thing you have to do, is make sure the name's available. You can register the name, and then you have a period of time to file your document. Again, that used to be more important when we had to mail things in. Now you just do it online. So I don't know that I've actually done a name registration in I don't know, 10, 15 years. So you can check right away, see if it's available, and then you get your articles ready and you file them online. We do them here. Our assistants are all trained to do that. And then I think now what your second question was the...
Unfortunately, I see a lot of businesses, and I wish that they would work with an attorney or a CPA who is very business focused. But a lot of times I see that they go through LegalZoom or something like that.
Right.
And, you know, especially if they're opening a franchise of something, it becomes very complicated because the name of the registrar is not on the documents at all. So if you can just give us any input you have, if somebody did choose to use LegalZoom, what are some of the issues or problems that somebody could run into?
Well, I think, like you said, it's a practical matter. If you're at the bank, the first thing the bank asks for is the articles, the operating agreement, and employer ID number. And, you know, if you don't have an operating agreement, all of a sudden you're scrambling around trying to figure out what an operating agreement is. And you probably haven't gotten an employer ID number, so you don't have that. So you kind of start off your relationship with the bank on the wrong foot. You mean now, as far as the business not putting the correct name on the legal documents, obviously that's going to screw everything up. You're trying to prepare loan documents, so you don't have the correct name of the borrower. So it's just you know, you think you're saving time and money, but you end up creating a lot more confusion. That's going to take more time and expense to correct it than if you did it right to start with.
Unfortunately, also potential fraud.
Yeah.
Especially if you're right, if it's a common name, really could throw up some issues.
Yeah, that's true. That's true.
Good. Are there any other questions out there? Phil, you're always good for a couple questions for us.
Yeah, I put my hand up here. That's a nice little icon. Yeah. Thanks, Mark.
I thought we blocked Phil.
Well, I was curious if you had an example of a sole proprietor maybe getting into trouble, or, you know, if you had an actual experience that you've helped someone as a sole proprietor that would have benefited if they just took the time and became a different type of entity.
You know, I guess I'm fortunate not to have anyone get sued individually as a sole proprietor. I think people pretty quickly move from a sole proprietorship to a different legal entity. And then so really what I have actually had experience with is when people don't set up the organization properly or don't follow the formalities. And then the creditors, when they realize that the company's not collectible, then usually it's a threat against the owners, and it just becomes part of the negotiation process, depending on the level of exposure to claims against the owners personally. But so fortunately, I've not had a sole proprietor get sued or have to defend against creditor claims. But, you know, as practical matters, it's better to not expose yourself to that. And one of the other issues is if you are a sole proprietor, whenever you fill out tax returns or you're issuing whatever tax documents you have to prepare, and with the bank, you're going to be using your individual social security number. So you're basically publishing your social security number all over the internet, which is not advisable. So that's, I would think that that would be something that you'd really want to protect against, to limit the amount of documents you have to put your social security number on. Okay, do you have any other questions?
Any other questions from the audience? All right, Larry. I think
Okay,
we're-
all right, okay, so the topic I'd like to talk about is the buy-sell agreement. Oops, we've got IP in here.
Yeah, just a little bit. You wanted to
Okay,
talk-
all right,
yeah.
okay, sorry, I got my PowerPoint on the line. So as I indicated before, we have a intellectual property group here, and what's important probably mostly for small businesses is protecting their name. In Ohio, you can file what's either called in Ohio, it's a trade name or a trademark. So a trademark is with a brand that goes with goods. A trade name is just a service entity. Typically, those are $25, I think, to file with Ohio, and they're good for 5 years. Now, that is not a U.S. trademark. The way the common law works with regard to trademarks is you would have your rights within your area and the territory where you're using the mark, but somebody outside the territory could use that name, and then you would not have those rights and outside of your specifically used territory. And then also you might be using your name and another company has a federal trademark. They can, and if they predate your use, they can come in and force you to stop using your name. There are, you can conduct, to get a federal trademark, first you do a search, and depending on the level of search, there's different cost ranges. But assuming that the trade name is available, the trademark's available, it can be done for about $1,000, the filing fee and the legal document preparation, as long as there's no oppositions to your registration application. Patents are obviously very complicated documents. It takes quite a bit to prepare a proper patent application, but once you have a patent, your use is protected for, now I should have looked this up, they changed the law recently. I think it's 15 years from the date of issuance. It used to be 17 years from the date of application, but within, as long as you're, if another competitor tries to use a good that is covered by your patent, you can get them to cease using it, and you can get monetary damages. So patents are very valuable, but they're more expensive to obtain. Copyrights are for written materials like books, and then also for music. They're relatively simple to obtain. So if you have anything like that, it's really very quick to file for copyright protection. And we have, I think, five or six IP lawyers. If there's any questions, I'd be glad to connect you with one of them.
Good. All right, so the next area is,
Oh, okay. This is so as part of the Defense Act that was signed last December, the federal government, and they've been trying to do this for years, but they snuck it into this defense authorization bill. So starting in January of 2022, if you are what they call a reporting company, you have to file a report with the federal government that identifies who the owners of the company are. And of course, the government promises to keep it confidential, but yeah, the government has their leaks also and their data breaches. So the question is what is a reporting company? And the way they define it is by what it's not. So if it's not a public company, because that everybody, you can look that up, who the owners of a public company are. And so if you're not exempt, to be exempt, you have to be a US based company with at least 20 full-time US based employees, have at least $5 million in revenue, and have a physical presence in the US. So if you don't have all three of those, you have to file one of these reports. Now, they have not issued the regulations yet on exactly what information they're looking for or what the form is going to look like, but presumably sometime this year, the government will issue regulations in this area. So just So you're aware of it. You know, if you have less than 5 million in revenue and less than 20 employees, you're going to have to be filing some report with the government that identifies who the owners are. So this is really unprecedented in the United States to require private companies to file this kind of information. The stated purpose is for money laundering. And I guess since we're being recorded, I'll stop at that.
Good. All right, very good. But just something to be aware that it is coming, and that's going to be a new reg.
Yeah. You probably work with your accountant, maybe the lawyer. I'm not sure who's gonna. The first year there'll be some ramp up for everybody learning how to do it, and then it'll be pretty, I suppose, pretty much administrative after that. But you need to work with your accountant or your lawyer on that one.
That's great. And before we move into our next section, Katie Anders offered about further commentary about LegalZoom. And what she shared is those who use LegalZoom also may have issues regarding this Ohio laws, as LegalZoom isn't always set up for a state-specific regulation. So just something to be aware of as we're thinking about it. So thank you, Katie.
So there might be something in Ohio that's not listed on the Zoom article, so it would get, I don't know if the state would reject them, but again, you'd have defective articles.
Right. Just further complications, right?
Yep, right.
So now, Larry, why?
Okay, here we go. Okay.
Yeah. Can I ask you a question before
Sure.
we begin? Why is buy-sell agreements so important to business owners?
All right. So the reason they're important is because a lot of times when you have more than one owner that's not family, at the beginning, everybody's in agreement on the purpose of the business, and the owners are able to reach agreements on what they need to do as far as where they're going to spend the money, who they're going to hire. As the company grows, becomes more successful, the owners may have different objectives, and they just are unable to reach agreements with each other. And perhaps more unfortunately is if the company becomes successful and valuable and something happens to one of the owners, then instead of dealing with your partner, so to speak, now you're dealing with the estate or some other group of third parties, maybe the lawyer for your partner, and all of a sudden the company's going to be worth a lot more when it comes time for you as the company to have to redeem the ownership interest of what the partner that is no longer able to work. Now that I don't know if the other conditions are, and this is kind of the unfortunate list of events that happen in life, but you can see them here: death, disability, termination of an employee who is also an owner, divorce, and then there's also other potential triggering events. And the idea of a buy-sell agreement, and the reason for kind of the funny name of the agreement, is if you have two or more owners that are parties to this agreement, you don't know if you're going to be a buyer or a seller. And given that unknown, most people act pretty reasonably. They don't demand an excessively high purchase price, and they also don't expect that the purchase price is going to be unreasonably low. So basically what a buy-sell agreement does, it enables the owners, when they're in agreement with each other and making decisions for themselves, to agree on, one, what are the trigger events that enable the company or the other shareholders to buy those shares, and perhaps secondly and more importantly is, how do you value those shares? If you don't have a valuation, what ends up happening, like in a divorce proceeding, the company thinks, then the other owners don't want to pay a lot for those shares, and the spouse's lawyer thinks that the company is worth millions and millions of dollars. So everybody hires experts, everybody hires lawyers. Sometimes you go to court and spend 2 or 3 years in court with experts, and all that can be avoided if you have a formula that the parties have agreed to when they're meeting with each other and able to agree on such matters. And if we can jump back one slide, I think, Judy, this is the first one. Okay, so I don't know if there's questions here. I could kind of jump into kind of basic structural issues and maybe then entertain some questions, because I might address questions you have. So there's two basic ways you can set up a buy-sell agreement. One is what's called a redemption agreement, where the company redeems the shares so that the company itself buys those shares back from the shareholder who's subject to a trigger event. The other structure is what's called a cross-purchase agreement, where the remaining owners purchase the shares of the owner subject to the trigger event, generally on a pro rata basis. And we'll talk a little bit later. This one of the issues with this is that the cross-purchase can get complicated if you have life insurance involved. And another issue is with the buy-sell agreement is you can either have, if there's a voluntary transfer, so it's not one of these trigger events, but somebody just wants to sell their shares, you can do a voluntary transfer, and the company typically will have a right of first refusal to match whatever the third party offer. A lot of times you can do, if you don't have a buy-sell agreement, you can put the right of first refusal in either the code of regulations or the operating agreement. And so you've at least addressed that issue in your governing documents, but you haven't anticipated what happens if somebody dies or becomes disabled. Okay, so then the next slide. Okay, so the trigger events, the obligation to purchase, so it can either be a mandatory obligation to repurchase or it can be an option to purchase. So typically what you'll do is if there's a death, that will be mandatory, because the widow's family is going to want the cash. They don't want to have a 20% ownership interest in a privately held company. They want to get the money, and typically the management and other owners would rather not have basically third parties becoming owners. So that one you typically have mandatory. The other events can be optional, like divorce, disability. You don't have to buy those shares, and you don't have to sell them, but if both parties have options to either require a purchase or to require a sale. So then I briefly mentioned the different valuations. The simplest one, and probably the most effective, is if the parties have a certificate of agreed value. And typically what we do here is, and this relates back from the days of corporations where you used to have annual shareholder meetings. What we always recommend to companies that have buy-sell agreements, that as part of their annual meeting of the owners, they also agree on the value of the company. Basically, you just take the company is worth $2 million, you divide it by however many shares there are, and then that's the per share value. And if somebody dies during the year, you take the number of shares they own, multiply it times the value per share, and that's the purchase price. Now, some people don't want to do it that way. And typically those are in effect it's best for 12 months. Sometimes people do it for 18 months. Problem with that is people either they can't agree on the value, or they just don't have it on their agenda and forget to do it. So what you want to do then, if you don't have a certificate of agreed value in place, is agree on a different method for valuation of the company. And I just have a couple here that are relatively simple. There are multiple books and articles written about different methods of valuing a company. I think these are just three that are simple to me. Whatever you want to do, you can write it up however you want to write it up. So typically a sales multiplier, my experience with like accounting practices and dental practices, those formulas are based on a multiple of sales, maybe 1 times annual sales, 2 times annual sales for the existing book of business. Another simple one is the book value, where you just take your assets minus your liabilities. That's your owner's equity or book value. And typically you'll multiply that times 2 or 3. So that book value is pretty straightforward. There's not a lot of complications. For larger companies, and if you've been around business, you hear the word EBITDA. So what that means is it's earnings before interest, taxes, depreciation, and amortization. And the reason they do that, so basically what they do is they take your earnings, which is your net income, so that's the before, and then you add back interest and taxes. And that's on the assumption that whoever the buyer is might not need to have debt, so there's no interest. And depending on their tax status, they might not have tax. So you add those back. D is depreciation, and that's a large number. If you have physical assets or real estate, you can take a large depreciation deduction against your income, but it's not a cash item. So basically you're adding back that charge against your earnings because it's a non-cash item. And same thing for amortization, which is if you buy equipment. Now, again, amortization under the current tax rules, you can expense things pretty quickly, so you aren't amortizing the way we used to have to, but to the extent you are amortizing, you add that back. So basically what EBITDA is, it's a true cash flow, adjusted cash flow number. So if you take your annual EBITDA and say that's 500,000, depending on the type of business that you have, so certain industries have lower multiples than other industries, and then also to the extent your company gets bigger, the more EBITDA you have, the higher your multiple is going to be. But so take a typical small business, it might have 500,000 to $1 million of EBITDA. Right now, EBITDA is kind of, we're all in a big funk here. Obviously, with COVID, we can't even have the barbecue at Phil's house because of the COVID. The Parma, what do you call it, Phil?
Rock and rib.
The rock and ribs you can't have. So this past
Sorry,
year,
got to correct you. It's rib and rock.
Rib and rock.
Right.
So this year we can't even do rib and rock. So how can you have a good EBITDA number? So there's a lot of uncertainty this year. So if you just kind of ignore this year, I'll go on to say how it kind of generally works normally. Before the pandemic, EBITDA multiples were very high, meaning that buyers were willing to pay a lot of money for businesses, and sellers were being offered so much money, it's hard to say no. So what that means as a practical matter is when EBITDA multiples get into the 10 range, so they're basically, a buyer's willing to pay you 10 years worth of your earnings to take on your business. Now that is really good if you're a seller. Right now, the deals are kind of quiet, but I kind of think that these EBITDA multiples are going to come down. But so I guess I kind of digress into sort of deal work, but that's kind of what your company is worth. It's what is somebody willing to pay for your company. So an EBITDA is a really good way to do that, as opposed to kind of your internal book value doesn't really reflect what your company's worth. So anyway, you calculate your EBITDA, and you can make whatever adjustments you want in your definition of EBITDA in the agreement, and then you agree on a multiple. So that is a value that's in place. You can have that, sign that today, and that same formula could apply in 10 years. You can always adjust it if you think the EBITDA multiple should be higher, but you got the basic valuation structure in place. A big benefit of this is for purposes of estate, filing your estate tax returns, and also in divorce proceedings. If you have an arm's length, previously agreed upon valuation method, the court and the IRS are going to recognize that valuation. Now, if you put in there some ridiculous formula that the shares are only worth $2, the IRS isn't going to go for that. And probably the divorce lawyer is not going to go for that. So it has to be reasonable, it has to be arm's length. I guess before I go into the purchase price, are there questions on, let me just jump through the payment of the purchase price. So typically what you want to do here, so now you've had a trigger event, for either voluntarily or on a mandatory basis, there's going to be a transaction where somebody's shares are going to get repurchased. You've got a value. Now, how is the company going to pay for this? So the standard provision is you usually do about 20% down at the time of the repurchase, and then the balance is set forth in a promissory note with a 5-year term, and the note sometimes is secured by the assets of the company. Sometimes you can get personal guarantees from the other owners. That's all depends on part of that you can address in your buy-sell agreement, but a lot of that's going to depend on the negotiation at the time. So even if it's in the agreement, that doesn't mean it always ends up in the documents. So one way to avoid the funding issue is you obtain insurance. Now, you can get disability insurance, but as a practical matter, disability is very expensive. It's for a limited time period, and there's lots of conditions and exceptions. So there are, I would not say, I mean, there's always a time when disability insurance makes sense, but you have to be very careful thinking that's going to take care of it. So as a practical matter, life insurance is usually very simple. You get a 10-year term policy for enough money that you estimate is going to cover either all or a significant portion of what the estimated purchase price is going to be. And then if somebody dies, you have the life insurance proceeds available to pay the estate of the deceased owner. And then kind of jumping back to the redemption versus cross purchase. So if it's a redemption agreement, it's very simple. The company just pays the insurance premiums. If somebody dies, the company collects the insurance proceeds and then you redeem the shares. If it's a cross purchase agreement, you have to have each of the owners buying the life insurance on the life of the other owners. And typically there are at least annual premiums of insurance. So you have to have a method to make sure those premiums are paid. And we have a number of agreements that are cross purchase arrangements. And we have what's called a cross purchase trust agreement, where you have to appoint somebody to be the trustee, usually a lawyer or an accountant, that acts as the trustee to process the insurance premiums and make sure that the premiums are actually being paid. So I think that's my general spiel on buy-sell agreements. I appreciate if anyone has questions or comments or life, experiences with buy-sell agreements.
All I would say to that is I wish I had one when I started a business and had a partner, but within 2 years it was apparent that we really weren't very compatible. And I ended up paying her everything she put in the business, even though for the first 2 years we really didn't make any money. But it got me out of the partnership, though. I paid for it.
Mm-hmm. Anyone else had experience with the buy-sell agreement?
So Larry, yeah, Larry, do you have any experience in the past that business owners did not implement buy and sell agreement and turn out to be in a really hefty sour relationship or anything like that? Do you have any of that?
It happens unfortunately quite often. We have one that ended up with the decision by the Cuyahoga County Court of Appeals. So you have to go through discussions between the parties. One of them files the lawsuit. So that's 1 year, then you got 2 years, and then you got 2 more years for the Court of Appeals. So so uncertainty for 5 years. It's just awful. So, a buy-sell agreement, typically the bare bones, if there's not a lot of back and forth, might be between $1,000 and $2,000. If it gets complicated and people want to write real fancy formulas, then it's not. It can cost however much time it takes to do that. But to me, it's kind of like talking about insurance. It's kind of like an insurance policy. You have it in place. You can always amend it if you think it's appropriate to amend it. But if you don't, you have that as the backup on how you're going to handle these situations. Yeah, it's just devastating. And where if somebody dies and then the widow's there and wanting to get bought out, and the remaining owners don't want to pay what the widow. I mean, it's just so you've had this relationship between the owners for a lifetime, and then it ends badly. Arguing about what the company's worth or how they're going to pay for it. So it creates a lot of personal, besides the monetary cost, it creates a lot of disruptions in relationships. Not having something like this in place.
In fact, it can break a lot of relationships on the back end, right? Including brothers and sisters and family members.
Oh yeah, we've had those. Yep, we've had those.
So it's just
those are the worst. Those are the worst. But
right. Thanksgiving dinner will never be the same.
No.
All right.
Well, speaking of which, Larry, I just want to say, have a nephew who has acquired quite a few properties, of which he renovated, and he's managing clients, renters in there. And he asked my son, his cousin, if he would like to partner with them, make a little bit of an investment, and that way they could work together on you know, little nuisance items here and there and whatnot, but, you know, kind of build their wealth together. They're
Right.
both single, you know, I call them single kids. They're in their 20s. They have lots of disposable income. They're living large, and they're very excited about forming this if it takes place. Well, I mean, listening to what you had to say here, it just it kind of reinforces my initial thoughts. They should really have some very firm agreements and a very clear understanding of what's going to happen, because I'm convinced they're going to continue to build wealth, and eventually one's going to get married, both will get married, they'll have families, and you're right, there could be a very sticky situation that could just tear the family apart if something were to go south, and things didn't go well. But so thank you very much. It's and of course I will recommend that they see you as opposed to some online.
Okay, appreciate that.
Right.
No, you know, as a business lawyer, I always try to counsel people to avoid litigation. And this is one of the best ways to avoid litigation, is the owners themselves make the decision, they put it in writing, sign it.
Right. And they do it before there's a ton of money on the table. So I think that's great.
Right.
Any other
So
questions?
Larry,
Yes.
yeah, one more question, Larry. So when you start a brand new like a business, of course you don't have like EBITDA multiplier, you don't know anything. So is that better off to start high or to start low, and when your business growing, and then you add more and more life insurance? How do you tell these new business owners that would like to put the protection, but they don't know where to start, what number to start with the life insurance? How do you do that?
As far as evaluation, and then how much
Correct.
life insurance
Yeah.
to purchase.
Yep.
I think you want to be optimistic, but not unrealistic about what the value is. If it's too high, then it's really not important. I mean, you get to a point where it would be so high that the other owner is going to say, well, I'm not going to pay that. So I think you have to be realistic. So which is kind of how it, I mean, like a book value kind of and a sales multiplier, the reason those are good is that as your company grows, then your valuation is going to grow automatically. The EBITDA, you know, you might not have much EBITDA for a number of years. You can have negative EBITDA, which is not a good thing. So maybe you don't use the EBITDA concept until you have, typically you want to have a pretty solid company that's probably doing 10 million a year, 5 million a year at least, before you start getting into an EBITDA type concept. But what you can do is you can have the basic structure where you identify the trigger events. You have an annual certificate of agreed value, and then maybe one of these backup valuation methods. And then as the company grows, you can always change the valuation method. And then as far as life insurance, I mean, if they're young, I mean, whoever just spoke there, I mean, 20-year-olds can usually buy $1 million worth of life insurance for $200 a year or something. So I guess it kind of depends on the age of the owners and their health. But if they're under 40 and relatively healthy, I think you can get term life insurance pretty inexpensively. I guess of course you have issues that people get older and and they can't get life insurance. Then you have an unfunded redemption situation. That's why you want the note with the 5 years so that the company has enough time to actually pay it. So I think you just have to use your reasonable judgment as to what's a reasonable value and what's a reasonable amount of life insurance coverage, depending on where the company is. And you can always increase them as you go.
Good.
Thank you, Larry.
Yep, thank you.
So as we're wrapping up here, Larry, just a few other areas.
Yep. Okay, so just some other things when starting a business. I think sometimes people think it's fairly simple to open a business and operate it. But I think if anyone's here has started their own business, they're going to find out quickly it's a lot more complicated than that. So, and you'll hear this, our banker's still on here, I'm sure the bankers and other advisors will tell you, I need to see a business plan before I'm going to loan you any money. So that's not a legal condition, that's just as a practical matter. And basically what that does is it forces you to be realistic about how long it's going to take you to become profitable. And in order to get you through that period, how much cash are you going to need before you start making money? You know, the cash burn is what these internet companies calls it. But as a practical matter, if you just want to open a coffee shop or a bar, you're going to not be making money for a while. So you're going to need to have enough money in reserve that you have available that you can go to, and I'm sure the bank will loan some of that money, but they're going to want to make sure you've got enough equity in the business that you're not going to just be going through the borrowed funds and then not have anything to show for it. It's important. Is the banker still on?
Yeah, there's very few businesses that I've seen who approached me without, and this is unfortunate, but approached me without a the exact document that you were talking about, because that's the strategy. That's how are we going to weather the storm? What's going to make us different in a business plan from XYZ company down the street? If you don't know that stuff and you don't put it on paper, you really haven't planned out. And there's very few businesses that I see, unfortunately, that survive after even 2 years without having that type of document.
Mm-hmm. So do you guys make, are they, I guess, I don't want to ask something, I don't want to answer, but do most businesses come in with a business plan? I mean, is that a condition to making a loan, or is it?
Most don't. And I make a strong recommendation, because again, we can't decline anybody from applying, but most don't, but I make a very strong recommendation that before you do go further, get that in place.
Yeah, and we call that working capital, but it's just cash.
Yeah.
Your receivables are working capital too, but if you aren't generating receivables and they get paid, you got to have the cash.
Yeah, and if I'm an investor and somebody's coming to me and saying, hey, would you invest in my company? If they don't show me what the business plan is for the company, if they can't tell me those questions, I'm not putting money in their hands.
Right. I think the next one on here is just, you have to decide if you're going to, most startups will just lease real estate, but at some point you might want to own the real estate, which is nice because obviously instead of just paying rent, you're developing equity in that real estate, but you got to come up with the money to purchase the real estate. There's employee issues. Unless you and your partner are the only employees, you're going to need to think through and talk to an employment lawyer about some of the issues with regard to that. So typically you do not have employment agreements in Ohio. Depending on the level and type of employee, you may want to consider that. Again, depending on the type of business, you might want to have non-compete and confidentiality agreements, which, the sooner, if you get those signed as they're onboarding to become an employee, it's more likely to be enforceable. If you're doing business in another state where you either have a physical presence or employees, you have to register in those states to qualify to do business, they call it. It's relatively simple, but you have to do it. You need to think through your tax issues. And if we have our next slide. Again, this is just kind of a recap of probably everybody on here would agree with this. It's kind of the small startup business guy that might not think about all this. Again, going to Zoom and filing some articles of organization. I have an LLC. I'm ready to go into business. Unfortunately, what you really should do is probably first talk to an accountant, make sure you got enough money to make it work, figure out what kind of tax elections make sense for the entity, get an employer ID number. So as long as you have either, we can do it or the accountant can do it, but you don't want neither to do it or both to do it. You just want one employer ID number. You should talk to a business lawyer like me or other business lawyer. There's the things we can go through there. Depending on the level of assets involved, you might want to talk to an estate planning lawyer about should have a will, but whether you need a trust or not. The estate tax is really high now. It's probably going to come down significantly. So whereas before tax planning as part of the state was not really a consideration for most people, most likely will become again. Depending on what employees you're going to hire, you might want to talk to an employment lawyer. And if you've got a trademark issue that you think you might want to get a federal trademark registration, it's good to talk to a trademark lawyer. You need funding for your business. Even if you have adequate equity, you want to have bank accounts, and probably you want to have a line of credit to cover your purchasing. So you need a banker to coordinate with. You should talk to an insurance agent, not just for life insurance, but for just the general business liability and the casualty events. So there's a standard sets of business insurance coverage you should get. I guess, with what's going on now with COVID, most standard insurance coverage in business, you could get business interruption coverage, but the COVID typically is not covered by a business interruption policy because it requires a physical damage event like a fire or a truck driving into something. And there's a lot of arguments back and forth about whether COVID should be covered or not, but at best all you're buying yourself there is years of litigation. So I don't know, Nikki, are there endorsements for COVID now? I don't even know if probably the insurance companies are running as fast as they can from COVID coverage.
Yeah, it's just a little bit layers. When the COVID-19 happened, the insurance underwriting approval a little bit tight now. And the approval time is going to be longer. Instead of 30 or less days now, it's going to be 60 days now.
Right, and the exclusions are going to be really clear going forward that COVID is not covered.
Yep. Absolutely. Yeah.
So,
Larry,
yeah.
there's a question about 1099 employees.
Yes.
What type of protection do you need for if you're going to have those?
All right. Well, I guess this is a whole area where, so with a regular employee, you have to pay the employees half of their FICA and FUTA, which basically there's a total of 15%. The employer has to pay 7% of that. And then depending on the size of how many employees you have, you may have to provide health insurance. So a lot of businesses say, well, I know what's easy. I'll just call them an independent contractor, and then I just pay them by 1099, and I don't have to worry about their health care, and I don't have to do any of this employee withholding. And the problem with that is just because you call somebody an independent contractor does not mean they're an independent contractor. And there's a whole 12-factor test, but the basic one is who has control over how that person spends their day. If the company makes those determinations and the person has to follow it, probably they're an employee. If they are an independent contractor, you would want that in writing. So like if they're a consultant and they're not full-time, you would want a consulting agreement that would document that if it were ever challenged by either the employee or by the IRS, that you would have a document that shows that they're legitimately an independent contractor and that they are compensated, or the tax document you issue for that is a 1099 rather than a W-2.
This is why someone like Larry is so important, because in all honesty, I mean, most people who go into business, they go in and they know what they are good at. If they are good at putting up garage doors, that's their ball, that's their. But if you don't have an accountant or an attorney who understands these things, just one employee can just sink a business by saying, hey, you guys didn't have the proper levels of liability. There was this issue I had with my taxes. Just one thing can sink a business.
Good, thank you. So Larry, I think we're on like the last.
All right, right at the wrap up. So the business essentials. So you want to, when you organize, you want to do it what we lawyers call duly organized, meaning you didn't just file articles. You've got either your operating agreement or code of regulations. You've had the appropriate meetings that are documented. You've coordinated with your accountant. So everything's duly organized. The benefit of this is you'll protect your personal assets, and that you'll have an entity that you can, well, I'll get down to that later. So you also want to coordinate your tax strategy with your tax advisors, and you want to have a team of trusted advisors, so not just the lawyer or the accountant. You also want, you know, people like Nikki for the insurance and wealth management, and you know, real estate people to the extent you have that. So you know, you're not just going it alone here. You can work with people who've been through these before. You can continue to go to webinars like this, and we always can learn more. And the goal of all this is that you can control your own destiny, and you can create wealth for your family. So that's America's a great country. Anybody can go start a business. You can grow the business and become wealthy. All it takes is a lot of hard work and just sticking with it. So I thank everyone for joining me. Yeah, I'm available for more questions. I'll stick around here later if anybody wants to contact me later. I'm at the office. We're fortunate we've been able to be here at the office for the most part. So I'm usually around here. I don't know if there's any more questions. Should we wrap up, and that if people want to stay, they can?
Yeah, I'd say it's to honor the 1 o'clock stop. I think we're good to go. If anybody wants to remain on the line and have a little chat with Larry or with Phil or with Nikki.
I did mean to say this before the buy-sell. It's going to be the questions you always wanted to ask your lawyer about a buy-sell agreement, but you were afraid to get a bill.
Right. Right. Very good. All right, everybody, have a great day. Thank you so much for being here. Stay on if you'd like to ask Larry a more intimate question or whatever you feel appropriate.
Not too intimate.
Not too intimate, exactly. Thanks so much.
Thank you
so
everyone
much,
for
Larry.
attending.
Thank you. Thanks,
Thank
everyone.
you.
I'll
Thank
take
you.
you out
Thanks
for
for-
drinks, Larry, for the intimate questions, but thank you so
Right.
much. Appreciate it. But
Okay.
Judy, thank you for moderating, and Phil, great job today. Take care, folks.
You're welcome. Pleasure to meet everybody. Take care.
Thank you. You, Judy. Thank you, Larry.
Bye, Nikki. See you.
Thanks.
Bye.
See ya. Bye.